It's fine.
Francis, yesterday we didn't see you.
Yes.
Where were you?
I had to go take care of something.
Nowadays I were.
Yeah.
Yesterday, when Nowadays assumed the seat,
Yeah.
she was like, she was playing mid-morning, what do you call it?
Oh,
She
really?
said it too.
Oh, wow.
Yeah, yesterday, Nanabe's birthday.
Yeah.
Oh, she did a great job.
I watched the video.
She did a
Really
great
good. I
job.
mean, two
Maybe-
piece in a pot. So no
The,
shaking.
that reminds me why she's the gammon. She's a
Gammon,
gammon.
yeah.
She is. I wanted to find out what her favorite drink is.
Favorite drink?
What is nowadays?
Nah. So what's your favorite drink?
One towel.
I don't have a favorite drink.
You don't have a favorite drink?
It depends on,
The mood.
yeah.
Okay.
So I don't have a favorite drink.
Top 3?
What I know is that I like beverages, like, not the drinks.
That's
As
how,
in,
what
I
do
like
you call
my
it?
tea, I like my coffee.
Okay.
Yeah. So I don't have like a favorite drink actually.
Conk, it has
Signature.
to be.
Yeah.
Okay.
The girlies, when you go somewhere, maybe there's Irish cream, you want to go and smoke, that's all. When you know, then Shandy.
Francis, what about yes?
I don't have a favorite, no.
Francis does not drink alcohol.
I don't.
So
You
only
don't drink
water
alcohol.
and
Water, fruit juice.
Fruit juice.
Yeah.
Okay, that's nice.
What about you?
this guy
I take a
Origin.
lot of water.
Origin is his favorite.
This guy?
I take-
Hey, really?
No,
You,
you cannot
Francis.
drink it.
It says you.
No, you can't
Oh,
take alcohol safe.
no.
It's
I take water a lot. So anytime you meet me, I have water.
his
No
voice,
matter what
his
you
voice
do.
was like the Origin. But he
Okay.
unfortunately can't take.
My boys.
Yeah.
Your boys.
Your squad,
You know
yeah.
them.
Squad.
Oh, that's right. We know them.
That is part of the squad.
Ha! I don't drink Origin.
You don't know. That is part of the squad that she's talking about. Yes. So we missed you yesterday, and Na was here with me. I almost dragged her to court because some of the things that she was saying,
Why? What
she has to be in court.
Hey, as in
Yes,
what?
Na has to be in court.
Okay.
What did I
Yes.
do?
He said,
What?
yesterday I told her she has to be in court.
This guy
As
is
what? A
lying.
lawyer?
Both.
Okay.
Both
You
has
know,
a
it,
lawyer.
you know the guy is lying. You are believing him.
Oh, but
What
why?
did you,
Oh.
when?
Yesterday,
I feel
she was
okay.
in the hot seat yesterday. Your seat, yes, and she was fantastic. So,
Where?
yeah, a lot of things that she has to be.
Hey.
We'll find it. Now we'll find it.
You
So-
don't worry. I know what to do today.
All right. Let's talk about what happened yesterday in court.
Yes. Yesterday, now he wanted to say something. Now wanted to say something.
So this matter of the Supreme Court decision on the celebrities and alcohol beverage advertising.
Yes.
Before you tell us about the decision, remind us of what this case is
Okay.
and
so-
how this case has traveled before the summary conclusion.
Yes. So Mike Darlington Osan in 2022 initiated this action. And the action was premised on a directive by the Food and Drugs Authority as far back in 2015. And what the Food and Drugs Authority is saying is that it has come out with a guidelines, and those guidelines are supposed to regulate how certain food are being advertised, how processes, how to guide. And one of the things that it states in the guidelines is that no well-known person or personality, for example, celebrities should be allowed to advertise on alcoholic beverages. So in effect, the Food and Drugs Authority is saying that no advertisements for celebrities and even no well-known persons. You and I are also inclusive.
Okay.
All that they want to do is to protect children because they notice that children are influenced when they see these people or these personalities advertised on them. And so for that matter, they shouldn't endorse alcoholic beverages. And they say that, look, the law is saying equality before the law, and nobody is supposed to be treated discriminately. The Constitution is fair to everybody. And so if the FDA is saying that, it means that it is being discriminatory against them. So the Supreme Court should look at Articles 17, 1 and 2 to say that that particular directive from the FDA should be declared unconstitutional, should be of null and void. And so they went to the Supreme Court. Anything that has to do with interpretation of the Supreme Court, it is the interpretation of the Constitution, I must say.
Yeah.
It is the Supreme Court that has the original jurisdiction to interpret it. No other court has. So Mark Darlington Osai went to the Supreme Court. He was seeking for reliefs. And I told you about the fact that on 2 different occasions, the Supreme Court has had the cause to adjourn or defer the judgment. So yesterday, when we were going to the court, we noticed that one thing was certain, one thing was in mind, to have the judgment delivered. And so the panel of 7 presided over by the Chief Justice yesterday indicated that, look, they have looked at the processes filed by all the parties, and they are of the considered view that by a 5-2 majority decision, the application should fail or the rates should be dismissed. The court said, having looked at it, they realized that that particular directive is not excessive, as was termed, that it's not excessive, it is not unreasonable. And the court is saying that they have also noticed that it didn't contravene the sections pointed out in the Constitution. So for that matter, they are endorsing the decision or the directive by the FDA. And out of the 7-member panel, yesterday only 6 of them sat. And the 6 of them were Justice Gertrude Saki-Tokonu, the Chief Justice. Justice Paul Bafo-Boyin. In fact, if you come to the Supreme Court, he's the most senior most. I said most senior most. Most appear beginning and ended. So he's the most senior of all the Supreme Court judges. Then you come to Justice Mariama Owusu. Justice Mariama Owusu was the one that dealt with the Major Mahama case. Justice Samuel Osiedu, and Justice Samuel Osiedu, he started the alleged coup case, and then later on it was upgraded to high treason. And in fact, one case that he's also dealing with at the High Court in relation to that audio tape involving former NDC chairman Samuel Ofosu-Ampofo and Kweku Anthony Boahin. And then Justice George Kingsley Kumsi. And Justice George Kingsley Kumsi was absent yesterday. But of course, his decision is conferred, it's part of the majority. So these are the 5 justices of the Supreme Court. By a 5-2 majority decision, the Supreme Court is saying that that particular directive from the Food and Drugs Authority to ban celebrities is affirmed. The 2 justices who dissented on this particular decision are Justice Barbara Akayenzu and Justice Henrietta Mensah Bonso. Of course, the Supreme Court is saying that the full reasoning backing their decision should be ready by Friday, June 21st. But in effect, what it is now is that no celebrity is allowed to advertise on alcoholic beverages because the Supreme Court has put an endorsement on that particular directive from the FDA. All celebrities are banned from advertising on alcoholic beverages. But what has been the reaction of some of the industry players? George Quay, who is the Chief Executive Officer of Image Bureau, was disappointed and said that this rather affects the Food and Drugs Authority rather than the celebrities in question.
I think what the FDA needs to do is to find a middle ground, to sit with these popular people and find the best way to ensure that we can all eat, we can all educate, we can all inspire, and we can all ensure that alcoholic beverages are not destroying our children. I have children, and I wouldn't be happy if some celebrity or somewhere is influencing them negatively. But I'll be happy if some celebrity somewhere is influencing them positively.
7-member panel of the Supreme.
Here's a fight that the FDA is losing already. Because if I attend an event and it's being sponsored by, what did you win? If I sit on radio and I read an LPM, what did you do? You understand? And then they would say, you cannot put an alcoholic beverage billboard within 200 meters of a school. When I'm taking my kids to school, do we fly? Do we fly from my house to that school? Do you know the number of alcoholic beverage billboards that I'll see on the road? When we stop in traffic, do I know what my kids are reading?
The Director of Legal Affairs of the Food and Drugs Authority, Joseph Benny was happy that the Supreme Court has affirmed their directive to ban celebrities from advertising on alcoholism. He says that they are ready to engage these celebrities to ensure that they educate the public, they educate the youth on alcoholic beverages.
Our point is endorsing alcohol. Yes, the youth are already drinking it. So what do? Do we allow them to do that? Do we still encourage them? No, we shouldn't. So the celebrities, the well-known personalities should rather partner ABA to ensure that we take them off the alcohol. So we do not endorse it rather, but we use their medium to educate the youth, encourage the youth that they can do some other things instead of depending on alcohol.
The executive director in charge of programs of Vision for Alternative Development says that the decision of the Supreme Court is a victory for public health advocacy.
For us, we are glad and we are happy that public health have won over over interests of some few individuals and who are just trying to amass wealth for themselves and not for the interests of the young people who are looking up to them for their interests.
From the Supreme Court of Ghana, Murtala Inusah, GH1.
Okay, so that's a wrap on that case. But I'm told there was some drama that came with this.
So there was a mixed reaction depending on where you belong to, how you take it and all that. So the president of Ghana Music Alliance and the executive director of Vision for Alternative Development yesterday after the judgment, it wasn't easy. Let's go back and check what happened and the argument that ensued between them for and against the decision of the apex court yesterday.
Mm-hmm.
Why do you think they are imposing on them? Because clearly they always write, do not drink if you're not 18 and over.
We've not banned advertisement.
But just
We are
not
only
with the celebrity.
exactly
So-
because of your influence.
Okay, but let's take for Michael Powers. When he came, he was a nobody. After one advert, he was a somebody.
Yeah.
Michael Powers cannot do a second one.
You see, it's just one individual. It's just one individual. We're talking about millions of children who are all over the
But
world.
don't you think
So please see-
any regular
see,
person that's
see,
used for an
see,
advert over and over becomes a celebrity?
You see, my problem is, you have just mentioned one individual, right?
But I'm giving you an example of
how many celebrities you have in Ghana here, and compared to how many cases you have in Chile. So the point, you can divert in many other areas of intervention, and you can still make your mark.
which other areas.
All the celebrities here, we have footballers who are doing advertisement on many other areas. I mean, they are into clubs.
But
they
you
are
have to
into
understand.
other
You have
things.
to understand that the product also has to have something with the celebrity, because you can't have a celebrity who really, a celebrity and musician really is about the nightlife and enjoyment, which is where the alcohol
You
comes
can
in.
go ahead and do it.
So you don't want me to be doing what?
Chief, no, you go,
What baby food?
Go ahead. Go,
Baby
go-
food.
Go,
No,
go,
don't worry. Shatawale doing baby food. Does that make sense?
It will go very well. It will
No,
go very
it
well
will-
for him.
Why would I
People-
make?
and people will continue. People will rather buy it. You
Why?
and
Shatawale.
it
What
will make
about
a mark for
Shatawale
him.
and Shatabites?
No, in fact, see,
That one you are scared.
No, you're scared.
Because you
Very
know what
scared.
will happen.
Very scared.
But you
Very
see,
scared.
they are not imposing on them. So that's why you get us
No,
wrong.
we are imposing. You see,
No, we are not
you- no, you-
imposing.
you don't
In
have-
no way.
you don't have
Are we
to-
imposing?
see, you don't have
but
to
you're using
impose.
the, you're
You
using the
don't
word
have-
impose,
no,
meaning
you are-
you are telling the kids, go out and drink. Go out. That's imposing. But we are not.
you know-
We are targeting the adults. The kids happen to see it. But at the same time, how about you make it a point that, okay, we cannot have adverts after, before 10 p.m. at night.
In fact, no, we want to send to him 12.
That's fine. So,
Yeah, that's
so
what we
then,
want to do.
so then the celebrity can do it then, because it's at 12. If your kid
no,
sees
no.
it, it is your problem as a parent
You see-
for allowing your kid to see it.
No, for that one, yeah, I agree. Because parents to ensure at least their children are asleep at a certain time.
So how about you also get to the parents and let them know, because the teaching of any kid to me starts from home. Let the parents let the kids know drinking is bad.
I
We
agree.
will also do our part to let the kids know that drinking is bad.
You are here today, right? But why are your kids?
I don't have any,
No,
unfortunately.
but see, my kids are in the school by now. By 12, they will be at home. At the mercy of what? TV.
Okay. So that's the
Yes.
argument that went down.
Yes, so president of Ghana Music Alliance versus against Vision for Alternative Development. The Vision backed the ABA's directive, and so they were happy with the Supreme Court decision. Of course, Ghana Music Alliance is the body that the plaintiff in question belong to, and so they also have a different view of that. So yesterday, after the judgment, that
They had their
particular
own peace outside the
conversation
court.
absolutely ensued between them. Quite interesting.
I'm sure
Depending on-
the conversations and the debates will
will
continue.
continue definitely, especially so when they get the full reasoning, and then we'll know what actually went into the decision of the majority and those who dissented.
All right. There was also the Cocobot case in the courts yesterday. What happened?
Yeah, so this very leg is in relation to the trial de novo, trial afresh. You notice that when Justice Clemens Onyenuga retired, the case docket was reassigned, and it was Justice Kwesi Jima who was initially handed the brief, and he said that, look, I am going to start the whole trial afresh. One of the things that he mentioned was to the fact that assessing the demeanor of witnesses in the box is very key for the court to examine that. And so for him, he's going to start afresh. Then the Attorney General appealed against that decision at the Court of Appeal. And the Court of Appeal overturned the High Court decision to start the trial afresh. Then lawyers of Dr. Opuni, Seidu Agongo, and Agricole said that no, they disagree with the Supreme Court of Appeal decision. So they went to the Supreme Court for the Supreme Court to overturn that particular decision of the Court of Appeal to allow for the adoption of Justice Clement Onyenuga's proceedings. But yesterday, a 5-member panel of the Supreme Court, as it were, sat, presided over by the Chief Justice Gertrude Tokunu, and they say that there's no merit in that particular request that was brought by Dr. Stephen Kobno-Opuni and Seidu Agungu and Agricole Ghana Limited. So they are reaffirming the Court of Appeal decision for the trial to continue by way of the adoption. But of course, the trial is already happening at the High Court, where Seidu Agungu is calling witnesses, defense witnesses in whole matter. Already the fifth defense witness is in the box giving evidence and facing testifying the whole matter. So yesterday, if the Supreme Court had granted that, it means that they have to come back to the High Court, and whatever had started, they need to stop and start afresh again. But per the decision of the Supreme Court, what is happening should continue. So no retrial, no trial afresh, as initially indicated by Justice Jima. And Justice Jima has since been transferred. He's one of the judges that have been transferred from Accra. So this very current case is before Justice Abaji Tando. Justice Abaji Tando is the one handling the case.
The
at the
matters of
moment.
now.
Yes.
Okay, great. The Beige Bank case, the case of 61. We are now number what?
Yeah, number 13 down.
Okay.
Number 13 down. So tomorrow we'll continue again. The witness came, testify, and in fact, his conclusion was that allegations that Mr. Nyineku, as it were, embezzles funds cannot be true, because they have evidence, they have document, they have proved to the court, they submitted to the court exhibit to show how each money or monies transferred from one company to other are expended, are used, and they brought documents, vouchers, and then statements to that effect to show that yes, Michael Nyineku did not benefit from those funds as has been alleged. So the charges cannot hold.
I see.
Yeah.
Now let's look to what's coming today. The big one
Yes, your favorite one.
is the
Is
ambulance
it your favorite
case.
one?
Oh, my favorite one. I think you know my favorite one. But we cannot talk about it
So your favorite
because
one,
it's not on the
one
list
is
of
in
issues
July.
today.
I know your favorite one is in July.
No problem. So, on the ambulance case, the cross-examination by the state of Richard Jakpa started on Tuesday.
Yes, in fact, it started before Tuesday.
Ah,
The very first day when lawyers of Dr. Kashila Tufosin ended their cross-examination, so prosecution was given the opportunity to, as it were, seal the map of a witness. When they are seeing the map, you ask them 1 or 2 questions. So they asked 2 questions that day. So those 2 questions were just elementary, primary questions. Are you there, Mr. Jakpa? They say, yes, okay, I'll seal your map. Then we'll come back. So the real action began last Tuesday. Yes. So today, we are expecting further cross-examination.
okay. By way of a recap, just a quick recap.
And so,
What were the highlights from Tuesday?
Yes,
And based
so-
on that, what are we to expect per the trajectory?
so the testimony or the focus of prosecution's cross-examination, first of all, was to testify or was to test the credibility of the witness. And so he realized that the DPP, the Director of Public Prosecution, asked questions in relation to how Mr. Jakpa went to the military, displayed insubordination, discipline, and was sacked. And at the point in time, he has to even fail examination one on so many occasions and all that. And because of that, he was sacked from the military. All to point out that you yourself, you are not credible before. And he said, no, I was. If you say I was sacked, I was not sacked. The only reason that what happened was that I was being victimized because my father, one way or the other, played a role in JJ's June 4th uprising, and the fact that when JJ was jailed, my father played a role in his release and all that. So when JJ, as it were, transferred him to certain places, they saw him to be a spy. So those officers there that he went to meet were not happy. They had an eye on him, so and all that. He also explained the encounter he had with the then Minister for Defense, Ado Kufuor. And he was admitting at the last court sitting, he admitted that, yes, in fact, he was the one that initiated the conversation between Attorney General. He took his number from his cousin, Justice Yoni Kolendi, and then engaged, had a WhatsApp chat with the Attorney General just so to introduce himself to him, because at the time that he was charged, he had issues executing the bail conditions and all that, so he had to call the Attorney General to come in to assist him. So he has been explaining how he got in touch with the Attorney General. But one thing that he's also been saying is to the effect that, look, I was not the one that decided the venue for our meetings, especially so when the House of Justice Yoni Kolendi was in question. He said it was the Attorney General who decided all that, and that cannot be said that he was the one that chose the venue. Another thing that he was confronted with was to the effect that he sent 68 messages to the Attorney General, and out of the 68, only 2 of them were answered. His response was that, look, I cannot readily remember how many messages I have sent, but the 2 that were replied, I do remember. But of course, he said that there were so many things that were discussed behind the scenes at meetings, so you only have to be by compliance. So once I send the message, it doesn't mean that there hadn't been a prior discussions and all that. So he put forth this whole thing, and he's also been telling the court how he's passed so many examinations out, and where, in fact, within 2 years, he has already passed some 25 examinations, some of them scoring as high as over 90% and all that. So those are the foundation. And one interesting thing that took place was that a question was asked as to the fact that he failed the promotion exam at the military, and that question alone, Francis, it took Mr. Japa close to about, in fact, the court can count about almost 4 pages to answer that question. And his position was that I want to give the court some background to why that happened and all that. So today, we expect further cross-examination. And one of the things that we should also look forward to is the effect that prosecution, he said that, look, the content of the WhatsApp messages that he brought to the courts are the relevant ones that he brought to support his case. So if the Attorney General also has his, because the conversation took place between the 2 of them, he also has his copy. He should bring those sides that he has exempted or excluded from his exhibit in court. The AG should bring it. And the Attorney General has found an exhibit, which was to the effect that the WhatsApp messages that transpired, by the 68 WhatsApp messages that they indicated. But the lawyers indicated that they were served in open court.
I need clarity on that. If it's 68 messages, is it 68 audio files, or it's just chat, hello, hi, this, that? Each chat or note becoming a message.
So what is not clear is whether there was a voice note, but what is clear to us is that there are messages, text, and then documents that Mr. Japa said he has sent to the Attorney General based on Attorney General's request. So these are the messages that form the 68 messages that we are talking about. So he is saying that. So the lawyers say that they want to look at the text messages or the WhatsApp chat that the AG has filed, so that if they have anything, they can have a conference with their client to know or to plan a strategy. So immediately they were served in open court. They couldn't have allowed the AG to go on with their questions. So they want time to look at it. So that even formed the basis for which the case was adjourned to today. So today we'll know whether they have some objection to raise to that disclosure filed by the state, or they will allow that to happen. And that day, Attorney General himself, in fact, he came in the early stages of the when the trial had already started. And Francis, that day we discussed something here about a recording.
Yes.
that was in circulation, and that was brought to the attention of the court
By whom?
by the Deputy Attorney General,
Okay.
Alfred Chiayepoa. He said, look, at the last court sitting, they noticed that somebody had recorded the proceeding. Then Justice Efia Sewasa immediately said, in fact, the judge asked Title Sorry if he has seen that particular audio, and his response was that not even as a rumor. So he has not even seen it, and he has not even heard it at all until it came to court. It was mentioned in court. So the court, before retiring, indicated that if that was the case, then the court will be forced to excuse virtually everybody in the courtroom, and the parties will be left alone, because that is not safe. And I told you about the fact that in the courtroom we do not record, we do not take videos and pictures and all that. And so after that was brought to the attention of the court, Justice Efia Sewasa retired and invited the lawyers, and when I say the lawyers, defense lawyers and the prosecution, into chambers. And then when they got back, that was when the Attorney General arrived. Then Mr. Title Sorry requested for a brief engagement with the Attorney General. So the judge retired again for about 5 minutes and got back. And when she got back, what she said was that an order is given to the national security to investigate the circumstances of that audio recording. And the court also warned that should that repeat itself, what the court will do is that to clear the court and the case will be heard in chambers. The case being heard in chamber or in camera means that it is only the accused persons, their lawyers, and the court. And the witness who will be testifying at one point in time who will be allowed in, not even the media will be allowed to cover. So that is what happened on that leg of the issue that we discussed here even before we went to court. And now that the judge's attention was drawn to, she has taken steps to do that. So these are all things that took place at the last court sitting. So today we expect further cross-examination. And Francis, one thing also was that during the case management completion plan, the court had agreed, or the parties have agreed, that prosecution will need 5 hours. So last court sitting, they were supposed to do 3 hours. And look at the manner in which Mr. Jakpa was answering the question. It will require that the court at the point in time said that no, I might be forced. The court will be minded to actually remove the ceiling, the 5 hours
on the number of hours.
Absolutely, because they feel that the way the witness is answering the question won't
lend itself to the time limit of 5 hours.
Absolutely. So we'll know more about it. If that had happened, then it means like today we'll have 2 hours from the prosecution to conclude their cross-examination. But that indication from the court as it stands, so we do not know how much more time the court will allow the prosecution to do their cross-examination. And also, lawyers of Dr. Kasela Tufosin said that they need some disclosures, and they will need it before the prosecution close their cross-examination. So that one also.
I remember that the lawyers for Atuforsen had gone to file some processes at the I think the Court of Appeal or the Supreme Court. I think it was the last 3 sittings, if I recall correctly. At the time they made the application for mistrial.
Mistrial, yeah, there were
there other applications made?
Yeah, there were. So one of them, in fact, lawyer for Richard Jakpa, Title Sorry, was the one who even indicated to the court that during the ruling that he has filed an application at the Supreme Court and want that ruling arrested. And the judge indicated that he doesn't have a copy on its docket, and for that matter, the business of the day will continue. Up until now, we haven't heard anything. But on that same June, the Court of Appeal delivered a decision on a case filed by Dr. Kasela Tufosin and Richard Jakpa. And what they were seeking was that they said that if you look at the charge sheet and the particulars of offense, it's defective. So once it is defective, it means that they want the court to strike it out. The Court of Appeal looked at it and was of the considered view that it is not defective, and so that particular request, if the court had agreed that it is defective, it means that whatever has happened in the trial would have been wiped away because the charges or the charge sheet is defective. So the Court of Appeal has cleared that. And what is also certain is that the parties have, that when the court ordered them to open their defense, they filed the appeal against that order, the submission of no case. Yesterday, they were at the Court of Appeal, and the Court of Appeal has, as it were, given them some directive that within 7 days from yesterday, the accused person and their lawyer should file their written submissions. Upon service on the prosecution, 7 days after receipt, they should also file their reply and then their statement of case. Then the court on July 30, that was a day before the court will go on recess, it will deliver its ruling as to whether the order for them to open their defense is right or wrong. So that is one of the legs of the cases that is pending at the Court of Appeal presently in relation to that. But that being said, today, Justice Efiasewa Saripoj, also a justice of the Court of Appeal, but is sitting as an additional High Court judge. In that, she has been dealing with this case before her promotion. So you do with it as a judge sitting with additional responsibility. We'll deal with the matter today and we'll know more. So
one more question on this before we move to other matters. And I have to do a hack back on the Cocobot case.
Okay.
On this ambulance case, now that the DPP has started the cross-examination,
yes,
is there any point where the Attorney General can decide that, okay, you started, but I can continue?
100%.
Sorry?
100%.
So it's possible that today,
it's 100%.
or Godfrey can come in and say, I want to do cross-examination.
Yes. Yes, it happens. So that is why it's a team. So the defense lawyers also is a team. So you realize that sometimes, let me use Dr. Kasila Tufos as an example.
His counsel.
Yes, his counsel, Dr. Abdul Basit Bamba and Eduji Tamakulu. So the day the controversy happened, it was Eduji Tamakulu that was doing the cross-examination.
Okay.
Yeah, at the last court sitting, the concluding part of it was Dr. Aziz Bamba that did the cross-examination.
But Faisora is lawyer for who?
Third accused, Jakpa.
Jakpa, okay.
Yes, Jakpa.
Okay.
And so, in this very case, the beginning of the case, all the cross-examination, Dr. Kasia Tufos witnesses, Mr. Sylvester Nevana, it was the Attorney General that was doing the cross-examination. He was doing the cross-examination. And there were only a few moments that the DPP conducted the cross-examination.
So it's possible that day one can be this person.
Yes.
So day two could be another counsel.
Absolutely.
Still of the same
it's a
team.
strategy. Once you are part of the defense team, the prosecution team, that was announced in the party. So
at any point you can show up.
Absolutely. So when the DPP doesn't come, Alfred Chiayebua will do it. If he doesn't come, they feel that Attorney General himself should do it if he is.
But
so
wait, what is the full complement of the team that's representing the state?
So the Attorney General's team currently it depends on who is present at the time.
Yeah.
The DPP will come.
Bobisa.
In these last few days that we have, the Director of Public Prosecution, Alfred Chiayebua, then Joshua Saki is in there. Ohene Bekwin is also in there. The House State Attorneys and some other. Then if the Attorney General comes, at the last court sitting, we have the Attorney General, the deputy the two deputies, Dinah Sonabadapa and Alfred Chiayebua. They were all present. The Director of Public Prosecution was present.
Was
there.
I think at the last two sittings there was Jambibi there as well.
Yeah, Richard is part of the team.
Okay.
Richard is part of the team. So even at some point in time, it was Richard who was coming. So it depends on the strategy for the day and who are supposed to be present. So today, it's possible the Attorney General will decide that no, let me take over from what the DPP has done. It's a strategy, and that is always possible.
It's always possible.
Always possible.
Interesting.
Yes,
on the Cocobot case,
yes,
you are giving indications of the Supreme Court reaffirming the Court of Appeal's decision.
Yes.
What does it mean for the Oponi trial?
So what it means is that what is happening now is continuing. If the Supreme Court had changed or arrested the decision of the Court of Appeal, what that would mean is that they will have to start the trial all over again.
I see.
Yes. So now that the Supreme Court has endorsed the Court of Appeal decision, it says that they will continue with the trial by way of the second accused person, businessman Seidu Agongo, and his company, Agricult Ghana Limited.
But who had made the request for the case to start afresh?
So it was the lawyers of Dr. Simon Puni and Seidu Agongo.
Okay.
They made their request.
For the case to start afresh?
Yes, because they were of the view that the courts, looking at what has happened in the previous trial by Justice Clemens Onyenuga, it will only be fair that, and in fact, it was during that time that the issue of criminal trial cannot be continued. It's only civil cases that can be continued.
Okay.
But of course, the court was of the view that, look, in order for the court to, in the interest of natural justice and also for the court to have the opportunity to assess, when you are talking to somebody face to face, you can just look at the person and realize that this person is lying. because of the person's facial, the person's look, the person's demeanor, and all that. The court said, I want to have the opportunity to assess the demeanor of witnesses who come. That's one leg of the duty. And the court also made the point that due to the controversies that have surrounded Justice Clement Chihonenuga's proceeding, the court do not want to inherit those controversies so that it will be seen as for the court. They want to start afresh so that it will have its own rules, its own assessment of the whole thing. But the Attorney General went to the Court of Appeal, and then the Court of Appeal agreed with the AG that they should rather adopt Justice Clement Chihonenuga's proceedings, and then that has been adopted, and they are continuing from there. And that was when the lawyers have also filed. The appeal was filed long time ago, but it was yesterday
That was
that
heard.
it was heard.
So now that this appeal was not upheld, right?
Yes.
What the clients went for, what the plaintiff went for was not granted.
The accused person.
The accused and granted was not was not granted.
Yes,
Do they have the option of a review?
they can. Yeah, they can always go for a review. So
I see.
it was a 5-member panel. So if you are going for a review, it will be enhanced to 7.
And then a
But
decision
it
will
was
be
a
taken.
unanimous decision. So if the unanimous decision is 5, and then they add 2, granted the 2
Dissent.
dissent.
That's 5-2.
The 5-2.
Still
But of
hasn't
course, the
changed.
Supreme Court is the only court that can
its mind.
change its own mind. Yes, they can depart from their previous decisions. So that's why they are not binded, or those earlier decisions are not binding on them at all. So they
Okay.
you can file a review and you may succeed.
All right. The Afoko retrial. Where are we on that? And what's going to happen today?
I beg your pardon, sorry. So prosecution is calling witnesses. This is the 3rd trial in over 9 years. So the case started 9 years already, and they are still in lawful custody. So prosecution is calling witnesses, but unfortunately, the issue of the striking jurors is biting hard on some of these cases. So all trials that the jurors are required, as we speak, for the last month and beyond, has suffered. JB Dankwa, Kaswa Rachel Ameda, and the Kaswa Rachel Ameda are supposed to have the verdict sometime next week. A lot of the cases, these have been seen murder, all of them have suffered one way or the other because of the fact that the jurors are striking. They say that they are owed 10 months unpaid allowances as at May, and we are in June. So then they went on strike on 16th of May, and today is what, 20th. That is 1 month,
Yeah.
4 days, and still counting. So we hope that the court will hope that they'll be back sometime this week. The checks that I did sometime last week was the fact they were supposed to have been sorted out as far back as Friday, so that on Tuesday, Monday was a holiday, so Tuesday they could start work, but that didn't happen. So yesterday, on Tuesday, they were not in court. Yesterday, I didn't see them, and we are hoping that maybe today. So we'll find out from their focal case if indeed they are back. If they are not back, then of course the case have to suffer again by way of an adjournment.
I heard her narrate what happened in the robbery incident. I think she granted, either spoke at a public forum or granted an interview. The
Yes,
former
former
second lady.
lady. Yes.
What's the updates on her case today?
Yes, when you listen to that kind of, it was more like she was delivering a sermon.
Yeah.
Yes, and if you listen to it, wow. Of course, the court will not work with that. Whatever is said in court, what the court will work on that. So that at the last court sitting, prosecution indicated that they filed the last batch of their disclosures and witness statements. So Justice Lydia Osemafo indicated that if that was the case, then all the parties, the prosecution should ensure that the defense is served with copies, so that today there will be case management conference. So the case management conference is a pre-trial hearings where the court will find out from the parties what the prosecution filed. Is the accused person and the lawyers having the same thing? Is the court having the same thing? Then they'll compare notes. So the court will be the one leading. Okay, do you have this document? Accused person, yes, we have. Do you have that? You have. Okay, do you have this? We don't have. So when was it filed? How come we didn't have it? Oh, we have served them, but we noticed that we had ABC. So they do all these things. So if all of them are on the same page, then it means the way is clear. So now the court will proceed to do what we call case management completion plan. and based on the witnesses that are available, and then they'll start fix a date for the trial to begin. And when the trial is beginning, it's the time that the prosecution is calling their witnesses. That's where we say the trial has begun, or the trial is beginning. So when you say the trial begins today, it means that that day, prosecution is calling the very first witness to come to court and testify. And prosecution prosecute their cases using witnesses. Yes, so that's what will happen. So today we are expecting case management conference. Then we'll know
the date set for the trial to begin.
The indication is that prosecution is likely to be calling about 9 witnesses in relation to this matter.
Okay.
Not only the former second lady alone, there are 4 other businessmen who are also part of
this
case. Yes.
I see. All right. The other matter has to do with Bra Sami Foto Samuel Ufuswampofo, the former chairman of the National Democratic Congress.
Yes.
Remind us of his case and where things are going today.
Okay, so for many who remember some alleged leaked audio that came out, in fact, this case was referenced during the Richard Jakpa, when the prosecution raised objection about Richard Jakpa's audio, whether it should be admitted in evidence or not. Prosecution, the different accused person referenced, the same lawyers who are involved in this case. Dr. Basit Bamba is involved in this case. So that case has been pending. Prosecution closed their case. They called 3 witnesses, and the court held that there's a prima facie evidence for the accused persons, the Mr. Samuel Ofuswampofo and Anthony Kwekubuanyi, the former deputy communication officer of the NDC, to open their defense. But for some time now, it's been over a year, the case has, as it were, stalled. And the reason being that Samuel Ofuswampofo is unwell. He's had to travel out of the country for some surgeries and all that. At the last court sitting, the court indicated that that day, the accused persons will be asked to, in fact, the second accused person, Amati, will be called upon to open his defense in the absence of Samuel Ofuswampofo, because the court held that it is dragging. But the lawyers also were of this view that if you look at the nature of the case, Samuel Ofuswampofo should be the one to testify first, then Anthony Kwekubuanyi will follow. At the last court sitting, they brought an excuse duty that the man is in town, and we know that Samuel Ofuswampofo is in town, but he suffered some post-surgery complication, and one of the legs is swollen, so he was unable to come to court. So at the last court sitting, which was around the 25th of last month, May, they were hoping that within 2 weeks we would have been okay. The court, in its own wisdom, added an extra week, which is 1 more week, and made it 20th. So today is the day that we are expecting Samuel Ofuswampofo, the former national chairman of the NDC, to be in court to open his defense to the charges of causing harm and then conspiracy, especially so when it's been alleged that they have thought to assault the chairperson of the Electoral Commission and the chairman of the Peace Council. So that is the leg of the case. And today, before Justice Samuel Isiedu, is now a justice of the Supreme Court, I told you it's one of the justices who actually agreed with the FDA to ban the celebrities and all that. So that case is also coming on today.
Okay. All right. Quite a packed plate for you
Absolutely.
today. You look ready for it.
Absolutely. We are
no
ready
problems at all.
To fire.
Yeah.
Yes.
Fired up and ready to go.
Sure.
Thank you, Murtala, for that
Thank you,
this morning.
Francis, and have a great day.
You too. Let me go for a short break now. When I return, the president has given a 2-year extension for the Auditor General. We'll share with you the details of that statement and also get some reactions to that. Plus, it turns out that the former, the Judicial Secretary, has had something to say about the work they're doing and the challenges they're in. We'll hear him. We'll also find out what's trending, and then we'll let you have your say. We're back after the break. Stay with us right here on Morning Star.